Senate Bill 379 on page 3 is the first of the mandatory child abuse reporting bills. And I think, Mickey, we may want to, right after we do 379, we may just want to skip over to 412 because they're both mandatory child abuse reporting bills, and they can be somewhat confusing because they're a little bit different. But Senate Bill 379 was originally written for the teachers, for the schools, because the legislature was very concerned about mandatory reporting and the sometimes lack of it and the lack of understanding of mandatory reporting on the part of teachers and school personnel. So this was largely for teachers. But there was one little piece of it that's very important to us, because for a long time now we have heard people, and the legislators have heard people who make child abuse reports complain that they make this child abuse report and they never hear anything back. They don't know if anything was done about this or not. And so what the legislature said was that what will happen if one makes a report of abuse, whether it's a mandatory report or a voluntary report, what will happen is that after the assessment is completed, the agency will get back to the reporter if the agency knows how to get back to the reporter. In other words, if it's not an anonymous report. And if you're a mandatory reporter, by the way, making anonymous reports, stop that. You could get in trouble for doing that. You need to make that report orally, and you need to make it in person. Why? Well, first of all, because the statute says that. But most important, because if you make an oral report, the person to whom you're reporting can ask you questions and can elicit information from you about the situation that you don't necessarily know is important, but is important to assessing the case. So always make your report orally by phone. So if the agency knows who made this report, the agency will get back to that person and will tell that person some very limited information. The first information is whether or not there was contact made with the child. The second is whether or not this case was assessed that abuse had occurred. And third, whether or not services were going to be provided. Okay? Not the basis upon which the services were going to be provided, not what services were going to be provided, but simply whether or not services would be provided. So the agency will be reporting that information back to people who make reports of abuse if they have the ability to get back to that person. And I think Mickey wants to talk a little bit to DHS people at this point about supporting school districts in doing this training. Is that right, Mickey?
Yeah, just very briefly. Thanks, Timothy. And a couple of comments for DHS staff about the bills. As Timothy mentioned, this was primarily an education bill. It also came through the education committees. So I want to clarify for DHS staff that when we need to get back to the reporting party, this is beyond teachers. This is for anyone who makes a child abuse report and we conduct an assessment. And not just for mandatory reporters. It's for anyone, as long as we have the contact information to get back to that reporting party. There's also a section in the bill that doesn't affect DHS, but we are getting a lot of calls, or we're hearing that the local offices are getting a lot of calls around training. And this bill talks about training for teachers around mandatory reporter training, but also training for parents who have children in a school district and for children who are in that school district. And during the testimony, the sponsor of the bill and the committee members who passed this bill were very clear that that is the responsibility of the Department of Education. It's not the responsibility of the Department of Human Services. Now, that being said, we know we have a great partnership, we being DHS. We have a great partnership with the Department of Education. At the local level, you have a great partnership with your local school district, and we want you to continue that, and we want to encourage you to continue what you're doing with your local school districts. We found out in a brief survey during session, most of the local offices are at least making available mandatory reporter training to teachers, and we want you to continue doing that. And in fact, Una Swanson, who is our statewide CPS manager, is revising the mandatory reporter booklet and also the videotape. And she's taken the videotape and turning it into a DVD, and she's ordered 500 of those, and we're going to distribute those to all the school districts in the state of Oregon. You still may be asked to help them with that mandatory reporter training, and we hope that you'll be able to do that. If the school district calls you and asks, do you have a curriculum or can you help us on training parents and children around child abuse prevention, we don't have a curriculum in DHS for that. However, UNA is working with the Department of Education to identify resources at the state level and also at the local level. So if you're getting calls from your district and you don't know where to go, if you would call Una Swanson, she can direct you or your district to someone in the Department of Ed who can help them. They're struggling with this as we are. You'll notice that this bill went into effect in June of 2007, so it's already in effect. Yes, ma'am, Barbara.
I was going to say, on cable access, PCC occasionally runs this. And I know it has Don Richmond, the branch manager at Gresham, as Linda Lee spoken. They do a half-an-hour training every once in a while on cable access.
Is that mandatory reporter training?
Yeah.
Excellent. That's great. Love technology. Yes.
I'm acquainted with some parents who believe their child was abused by a babysitter and took the child to the pediatrician, who's a mandatory reporter, and she reported what she believed was abuse. And the parents were never able to get any information about whether it was investigated or anything. Would this correct that, or would it go back to the pediatrician and then the parents could find out from the pediatrician? How would that work?
I'm going to check with legal counsel, but I believe the bill is written to get back to the person who made the report.
The bill is written to get back to the person with the report, but the parents, I think under your administrative rules and under the law, DHS could disclose information, and we should in most cases, to the parents so that they can actually protect the child from this person out there that might be abusing.
And just get some closure about what had ever happened.
Right.
Those folks need to call the CPS or DHS.
And I think your question really got to the heart of what I think the sponsor of the bill was trying to do, at least from a DHS perspective, and that is, if we close the loop with the person who makes a report, or like in your example, even the parents who are protecting their child and trying to support our system and working with them, if we close that loop, we actually encourage the community to make additional reports of child abuse. So this works almost in a preventative, maybe not a preventative way, but it works in a way to better protect children in Oregon if we do that. And, bottom line is, as Timothy mentioned, I'm from the South. That's just manners. I mean, people that take the time out of their day to pick the phone up, put a call into us, and make a report, the least we could do is bring closure to what it is that they're thinking about and say, thank you for making the call, and here are 3 things I could tell you about that call and where we ended up. And I think that's going to go a long way for us as a department. Thanks.
The 2 other things I want to say about this bill is, first of all, that really one of the intents behind it is to create some transparency in our system. When people don't know what we're doing, they assume the worst, which is that we're doing nothing. So by getting back to them, they know that something happened with the report. The other thing, which is probably not important to most of you, but it may be of interest to the lawyers in the room. Lawyers are the only people who are required to be trained on mandatory child abuse reporting at pain of losing their licenses, have personal responsibility to be trained once every 3 years. This bill does not put that same responsibility on teachers. The responsibility is on the school district to provide the training. It is not on the teacher to have the training. Moving on. Oh, go ahead.
I have a question. The question is, when you're getting back to them, is it the hotline that's going to be getting back to them, or is it the worker? Because what if cases are not open?
I'm not really sure. I think it's probably the hotline, isn't it? I don't know.
Yeah, my guess is that's going to. I don't think it matters who gets back to the reporter, just so long as we bring closure to them.
But if you don't have clarification on who it gets back to, it's going to end up falling in the trap.
But that's a local issue.
That's something that's going to be that.
And I'm going to guess that the rule's going to spell that out. It's not in the bill, but.
Oh, okay.
I mean, it's going to be different in the Alberta branch, which is enormous, as opposed to the Gillum branch, which has 2 workers.
And
so
okay, as long as it's in policy, I was just wondering.
Well, I think you need to get that clarified.
And this is an important thing to bring up at some point, and maybe now's the time to do it. Wait. Let me finish. This bill, like many bills, is going to require the agency to write rules. Some of those rules are written and some of those rules are not yet written. And the reality of the world is that just because a bill goes into effect doesn't mean that everything is in place to put it into effect. So if you're from DHS, you're going to have a rule written about how to do things. And if you don't know what that rule is at this point, then you should be talking to people, your supervisors and such, to find out what that rule is. Now, supervisors in the back of the room.
Okay. Well, I'm not a supervisor, but here in Oklahoma County and when the laws on hotline, the screening practice has changed to reflect the intent of that legislation. And so when people, when callers make a report to the hotline, the screeners, once they've made a decision about what's going to happen to that report, whether it's going to stay, documented and it's closed and there's not an assessment, or it is going to be assigned a recidivist assessment, the screener is supposed to give that information back to the reporter, either at the time they call or they would call them back when they consulted with their supervisor.
But that's only part of, that doesn't cover what's required in this bill, which is that after the assessment is completed, you get back to the reporter.
Right. I just wanted to address this concern about reports that don't get to that stage.
Right. And that's been a question that we've had throughout this training is, what about a closed screening? So as I say, if you are unclear about what you should be doing, you should be seeking guidance from people who know. And if they don't know, they'll find out from people who do know. And then if they report to somebody and nobody knows, then we know we need to make a policy. Senate Bill 412 over on page 5 is our second mandatory child abuse reporting bill. And this one's a little different. Although the intent is the same. The intent is the same, I think. It's transparency of process. What Senate Bill 412 says is if a child is in foster care and there is a report of abuse or neglect on that child, the information that a report has been received will be forwarded to the parties in the case. Parents, DASA, child attorney, parents' lawyer. Okay? But that's all that's forwarded. And that will happen within 3 days. And that's it. Just the fact that the report has been received. No further details at this point. And now, Mickey, I remember at the beginning, had you cross court out in his handout? Don't tell the court about it. Okay? Only the parties. Don't tell the CRB about it. Only the parties. If some kind of a dispute comes up out of this report that needs to be resolved, the parties will bring that dispute to the court. But if the court has the information, what's the court going to do with it? And we got plenty of disputes to resolve without going out and looking for new ones. So if something's going to come up out of this that needs court resolution, we'll hear about it. Now, there's an exception in this, and that is if the investigation would be impeded by notifying the parent or the parent's lawyer, the parent or the parent's lawyer will not be informed. They will not be informed that the report has been received. And the other parties who are informed are prohibited from telling the parent or the parent's lawyer that this report has been received. But that's if it would impede the investigation. Now, once the investigation is over, everybody who is a party to the case gets all the information about the report and the assessment. Okay? The only time that somebody won't get information is, first of all, when the only information is that there's a report, and second of all, when that telling those people would impede the investigation. Well, how could that be? I mean, how would that arise? That arises because this is not limited to reports of abuse or neglect of a kid while in foster care. It's if the report is received while the child is in foster care. We all know that sometimes kids come into substitute care, they get comfortable. A month or two down the line, they start to disclose abuse that occurred to them previously. And that's the situation in which the parent may well be the object of the investigation because the child is reporting something that occurred before the child came into care. So that's how we get to the circumstance of thinking that we're not going to tell the parent because it might impede the investigation, or the parent's lawyer, it might impede the investigation. And so what's going on here, what's behind this bill is transparency. It's transparency. I represented kids in this county for a number of years. And I know there were times I would get to court and I would find out in a court hearing that there had been 4 or 5 reports of alleged abuse on my client while my client was in foster care, and I didn't know anything about them. And the parents' lawyers would find that very same thing out. And you know what? That really makes us suspicious. You're getting reports of abuse about my client Karen, you're not telling me about that? Why not? What are you up to? What are you trying to cover up? Now, obviously, nobody's trying to cover up anything. But the fact is that that's what it looks like. So it's about transparency. Okay? And this, by the way, has been policy for a while. It simply has been unevenly used. So the legislature said, and you notice this is a 400 series bill. This came from the legislature. The legislature said, you want to report this to the people so they understand what's going on and they don't think the worst of what's happening.
In those homes where we have multiple children, where only one child is the subject of the investigation, are we informing parents' attorneys of the other children living
What
in
an
that home?
excellent question. The question was, if you have 2 children in a home, and they're not siblings, and you have a report of abuse on one, are you required to tell the parties in the case of the kid who the report is not about? And the answer is no. No. It's only the part. Now, if both are, obviously, then you are. But no, if there's no report of what may be abuse on the other child, you do not inform people in that. Yes?
Are we prohibited from telling them what the abuse was?
The question was, are we prohibited from telling them what the abuse was? Until the assessment is completed, I believe so, yes. I believe so. All you do is give the information that a report has been received.
So
Go ahead.
I think the bill sets a floor for what you have to tell people and who you have to tell. So it's the minimum you have to tell child attorney, parents attorney, and CASA when a report on a child in substitute care is received. If you think that it is appropriate to tell them, then I think that's a discretionary call, but you're going to have to assess that given that you might be at the very beginning of an assessment and an investigation, and you might not want to share that with anybody until you've completed that. So it may not make any sense to tell them.
I think it's just that if I call, the child's attorney, the parent's attorney, the CASA, and said a report's been made that alleges abuse in this home, I think the person would say, what is the allegation? And
under this bill, the answer you can give is, we're in the beginning stage of completing an assessment, and really that's all I can tell you at this point because it could interfere with our assessment. I mean, what you don't want is the child's attorney calling the child and starting interviewing them before law enforcement and DHS has gotten out there to talk to that child. Now, I think most attorneys would use some common sense and not do that, but they may not understand that that's an issue. In terms of the other children in the home, again, I think this is a minimum, and it may be appropriate to tell the attorneys for those other kids. What if it's a situation where you have to remove all the kids from the foster home because of the allegation? Well, aren't you going to have to explain to those other people why all of a sudden their clients got moved from that foster home? I mean, you've got to get...
They have to be, if they're removed, you have to inform them anyway.
Well, you have to tell them that there's been a change in the placement.
Right.
But I don't think there's a prohibition in this statute in terms of telling people information that they really should know and it makes sense for them to know. So there's not a prohibition necessarily. This sets the minimum, I think, of what you must tell people. Because as Timothy says, we were finding out that DHS was going to court sometimes more than once while a pending assessment was going on and nobody knew about it. And the court was making decisions and attorneys were making recommendations, and then all of a sudden, we have a completed founded CPS assessment, and gee, we would have done something different if we had known about that earlier. So,
and this is DHS, this is your legal counsel, not me. This is your legal counsel. So what she is telling you is better than what I am telling you. I share your concern, however, and I also share the concern that you may create an impression among the parties that you don't want if you inadvertently or advertently tell one party more than you tell another.
Yeah.
And that's why the safest thing in terms of keeping yourself on an even keel would be to tell everybody everything at the same time. But like I said, she's your lawyer, not me. So that is Senate Bill 412. Are there any other questions? Yes.
I just wanted to mention that I had this backfire on me not too long ago. I informed the CASA, then turned around and called the parent's attorney, who in turn called the parent. So before there was any investigation started, the parent knew that there was a report and what the report was about.
Right, and that's one of the things for people to really understand is that it is in statute that if you're informed and you're told not to inform a parent's attorney or a parent, that's a statute. And if you're an attorney and you tell somebody when you know you're not supposed to, or a CASA and you tell somebody when you're not supposed to, I think you might be putting yourself in a position where somebody's going to question your behavior, and it may not be a pleasant endeavor for you. I can't predict what might happen, but if you have a legal obligation and you don't do it or you violate it, I think you might have a problem. So, yes.
So would it be appropriate to say tell the child attorney or the CASA and specify that this is under investigation, please do not talk with the parent or their attorney together?
Well, I think, and that was, and subject to what Linda may say, I think probably what your protocol is going to be would be that's going to be part of the informing process. That this is one of those cases where under 419, whatever, we don't want you to inform.
One of the interesting things about the exception to providing notice, and the question for the camera folks is, can you tell the child's attorney or the CASA and then tell them not to tell anybody? Is that what you're saying? I think you can inform them that, of course, we're in the middle of a CPS assessment. Please do not share this information with other people. The exception to telling people about the receipt of the report applies only to the parents and the parent's attorney. It doesn't apply to the CASA or the child's attorney. So under all circumstances, you would need to tell the child's attorney and the CASA. But I don't see that there would be any problem with folks reminding the CASA and the child's attorney that in order to protect the integrity of the investigation, you would ask that they not share that information. And in fact, as Timothy says, there's a specific prohibition in the bill that says any person or entity to whom notification is made under this section may not release any information not authorized by this subsection. So I think that's a conversation to have with those folks as you provide the notice.
Okay. Are we good with that?
I'd go one step further when you're informing CASAs, reminding them of the legal requirements. You maybe, as I'm understanding this, if DHS makes the call that parents, attorneys, and parents are not going to be informed, never hurts to remind them of the legal requirements.
And for those of you in video land, the comment was that it might be a good idea if you're informing a CASA, who is a volunteer and not a lawyer, about this legal requirement, just to remind them that they need to guard the information. Okay, back on page 4 is Senate Bill 409. Actually, let's go back to page 3 and do 408.
Yes, please.
408 is a bill that came out of the legislature. It was one of their ideas. It came from the sensitive case review. What happened in that case that they reviewed was that the state filed a termination petition before the state went to a permanency hearing and had the plan changed to adoption. And what the legislature thought was that if the state had to go to a permanency hearing and explain the idea of adoption, in this case to a judge, that they might not have gotten that judge's permission to make the plan adoption, and if that had happened, a lot of things that occurred wouldn't have occurred. So now it's the law that if you're going to file an adoption, file a termination, that you have to have a permanency hearing first, and the judge has to change the plan to adoption. And of course, the only people who can file terminations are the state, in other words, the Department of Justice, or in Multnomah County, the district attorney's office, or the child. Those are the only parties who can file an adoption or a termination. And so they have to have the plan changed first. This does not change the fact that the agency can change any permanent plan anytime it wants to, and doesn't have to come to court first to do that. And, of course, if they do that without coming to court, they continue to run the risk that when they get to court, the judge won't like the plan that they changed it to, and then they'll be stuck with no reasonable efforts on the plan that the judge did like for the time up before the hearing. But you can still change the plan. All you can't do is actually file the termination petition, Senate Bill 408.
So, Timothy, this seems to put a lot more weight on the permanency hearing all of a sudden, or in some cases anyway, because now you're saying the judge, if the judge doesn't agree, is this going to lead us to more contested permanency hearings where they're going to be calling witnesses and that sort of thing?
The question is, what's going to be the impact on the permanency hearing of this? Well, I think it's always been the law that the judge was the last word on the plan. I mean, that's always.
See this as really
That was a big knockdown, drag-out fight when we conformed to Oregon statutes to the ASFA, and that was the resolution. You always run the risk that the judge is going to make a different permanent plan, and there you be. So it may well. I'm surprised at how few contested permanency hearings there are, but there are a lot of contested permanency hearings, and some of them get spirited. And again, this was a practice that was largely observed already around the state. This case in which they filed the terminating petition without changing the plan was anomalous, but nonetheless, there it was. So now we got a law.